Hello, everybody, to the State of the Mind. Today, we are going to speak about a particular editorial that I came across in the Hindu, the newspaper, the Hindu. This particular editorial pertains to actor Vijay. Actor, I won't call him an actor anymore because he himself has said that he's going to quit acting and he's going to get into politics. His last movie is Jananayagan, which is supposed to release next year, early next year, but then he's quitting movies. That's what he's been saying. So he's now a political leader. He runs a party, which is the Tamaraga Vetrik Kazhagam, which we all know has gotten into the news for the wrong reasons recently because of the Karur incident, which pertains to the stampede which happened in Karur in a public meeting called by him, where almost about 41 people lost their lives and several others were injured. Now, this particular issue went to the courts. It was deliberated in the Madurai branch of the Madras High Court, and then the Madras High Court single member bench, even as the division bench of the Madurai High Court, was uh, seized of the matter, had taken up this issue and had suo pass some orders. Now, this was contested in the court of law, in the apex court, in the Supreme Court, and the Supreme Court came out uh, with certain orders, which were, of course, interim orders, and these interim orders, or the interim order per se, has been criticized by the Hindu. Now, we don't have a problem with the Hindu criticizing the interim order of the Supreme Court because every court, they are susceptible to criticism. And I would say that I would even welcome criticism, but then that criticism should not be flawed. Now, the Hindu has come out with a particular editorial, which is itself titled "The Flawed Order." Now, how does it find it flawed? Actually, you will find that they have twisted the they've made certain claims which are twisted, not what the court actually said. So let's get into detail about this. I would just read out the. I think it is better that I read out uh, the editorial. So the editorial is titled "The Flawed Order." So let me read out the contents. It says the transfer of the Karur case to the CBI raises troubling questions. More than 2 weeks have passed since 41 people died after a crowd crush at a political rally of actor politician Vijay and his party, the Tamil Nadu Vetrik Kazhagam in Karur. Yet, far from establishing culpability, now just note the words, far from establishing culpability, the judicial response risks prioritizing political narrative over factual inquiry. Now, this is where we have an issue. It says, far from establishing culpability, the judicial response is risking prioritizing political narrative over factual inquiry. Now, culpability, that is a different, that's a very important subject here because it is a public meeting where the police were accountable for having granted the permission and for having agreed that they would provide protection where they are alleged to have failed to do so. Now let's come to the other part of the other part of the editorial. It says on October 13th, the Supreme Court of India's intervention, transferring the investigation to the Central Bureau of Investigation, the CBI, and appointing a supervisory committee was ostensibly meant to restore order after procedural disarray at the Madras High Court. The court's move seems to have arisen because of the sharp remarks, perhaps unwarranted, by a single judge at the Madras High Court. Thankfully, they've agreed that it could have perhaps been unwarranted what the single judge had spoken, because the single judge had given out certain statements. Of course, it is all under obiter dictum, but still he had made those comments which spoke about whether Vijay has leadership qualities, etc., which is not required. Of course, uh, I had tweeted about it also, and I was also brought under the scanner of prosecution for that, for just having tweeted that. But now let's come to the editorial about Mr. Vijay and the TVK, neither of whom was a party in a case about rally protocols that did not directly concern the Karur incident, because there was a petition seeking for SOP, special operative procedures, for such meetings. And in that particular petition, the court comes in and gives directions, gives comments, makes observations about Vijay's meeting, his party, his leadership qualities, and the stampede, the unfortunate stampede incident that happened there. Now, the problem is the Madras High Court has actually gotten into the incident which happened in Karur. So, very clearly, this falls under the Madurai bench of the Madras High Court's jurisdiction. But the court has created new problems. That's what the editorial goes on to say. It has granted the petitioner's demands for a CBI investigation. Now, who are the petitioners? Just not Vijay. Vijay was one of the petitioners. There are other petitioners. The other petitioners, some of them were victims who have lost their kith and kin in that particular stampede. Now, let's get into the editorial again. It has granted the petitioner's demands for a CBI investigation and judicial supervision as interim relief. Yet, the measures are irreversible. Once the CBI files a charge sheet, there can be no reversion to state police investigation. Fair enough. The court's rationale for the CBI transfer is equally problematic, says this particular editorial. Now, why is it problematic? It cites press conferences by senior state officials as attempts to exonerate subordinates, casting a doubt on investigative impartiality, but this amounts to a gag order on public officials. After the incident, Mr. Vijay and his supporters, they alleged conspiracy. Should state officials refrain from responding to grave allegations amplified across social media merely to appear neutral? Presenting factual evidence, including footage, should not automatically prejudice an investigation. This is too flimsy a ground for a transfer of the case to the CBI, once described by the court as a caged parrot of the center. Ironically, the court cited State of West Bengal and others versus the Committee for Protection of Democratic Rights, West Bengal and others. The citation is pertaining to the 2010 verdict, which warns against ordering CBI investigations as a matter of routine or merely because a party has leveled some allegations against the local police, undermining its own reasoning. The order devotes considerable attention to police inaction and crowd management failures, but makes no mention of the TV case or leaders' responsibilities in organizing the rally. The court may be seen as prejudging who was at fault. It notes that the TVK was not made a party in the High Court proceedings, yet does not consider what this could mean for a balanced inquiry. Following the interim order, it is unclear what remains to be adjudicated at the final stage. It remains to be seen how the court will address allegations that one petitioner was unaware of the petition filed in his name is not a real representative of a child victim. Justice requires affixing clear responsibility to deter chaos, not proceedings that muddy accountability. The editorial actually goes on to say, I just read out the editorial to you. The editorial actually goes on to say that the SC's reasoning, the Supreme Court's reasoning, amounts a gag order on officials. This is a false claim. I will tell you why. The court never barred statements. The court never barred statements. It just said cops and senior officials' media remarks could create doubt about probe fairness. That's caution, not censorship. I'll tell you why. Because when an incident happens and people start making their own random claims online, and then there is a media trial going on, and even as the media trial goes on, you have the officials, the state officials, the cops coming out, holding a press conference and exonerating the government, then there is a need for an investigation. And the court never said the cops or the officials should not come and make those statements. Whereas the editorial says the court put a gag order. No, it did not. So, one twisted claim. The first twisted claim. Anyone familiar with how justice works knows that conclusive public remarks. If a police officer, if a police officer in the grade of an ADGP is going to make conclusive police remarks, public remarks, then that can compromise the integrity of an ongoing investigation. The chief minister has ordered an investigation by a retired judge. And even as the chief minister has ordered that, if a top police official is going of the same administration which has ordered the investigation is going to come out and make a press meet, a statement in a press meet and exonerate the government or the officials, then where is the need for an investigation? This will raise doubt. And yes, the court did cite the West Bengal government of West Bengal versus the state of West Bengal versus CPDR 2010, but used the extraordinary power because of high political sensitivity, procedural confusion, and cries for credibility. This fits exceptions, not routine transfers. SC acted to restore consistency in conflicting orders from the MHC. Now, the Madras High Court has two branches, one in the Madurai and one in Chennai. Now, if there is going to be a division bench which is seized of the matter already, and if there is going to be a bench in Madras, a single member bench in Madras which is going to come out and pass an order suo motu on a petition which does not even concern that particular topic, then I think that means there is a confusion. Then the Supreme Court has to step in, which is exactly what it did. And it takes cognizance of the fact that there were officials who went about making those statements which were perhaps not illegal but then irresponsible. Should the Supreme Court not take into cognizance of that matter? Which is exactly what the petitioners wanted the Supreme Court to do. And he did that. And then let's go back to what the Hindu editorial says. The Hindu says CBI transfer is irreversible. Once you have ordered for a CBI transfer and once a charge sheet is filed, it is irreversible. Again, this is wrong because the Supreme Court's order itself is interim. It can be modified or revoked any time. And if new facts emerge or petitions prove fraudulent, as is being claimed, because there are some claims that there are 5 petitioners apart from Vijay who claim to be victims, and 2 of them have come out in public and stated that they were not aware of what they were signing, and they just signed the documents, and then it so happened that it happened to be a petition. They're not aware of it. That's what they claim. So the court said we will investigate into that as well. Now, if it is proven to be fraudulent after fair investigation, then legal reversibility becomes possible. That can happen even after charge sheeting. So where is the question of if the charge sheet is filed? Who told these people that there cannot be the interim order cannot be reversed? There is no such provision in the law. Law provides for you to reverse the orders. That's why it is called as an interim order. And it alleges, the particular editorial alleges no mention of organizer responsibility. The fact is, the Supreme Court appointed Justice Ajay Rastogi committee explicitly monitors all culpability, be it the party, be it the police, be it the outside characters, which there are allegations that outside suspicious characters came in. All of this is going to be investigated. So it means it includes TVK's planning and crowd control lapses as well. And then let's see the other point. The Hindu editorial claims, SC saw press briefings as bias. Of course, it was a bias. But SC only said early public defenses by senior cops when the investigation has been declared. or an investigation has been announced by a retired judge, if there is going to be an early public defense in the public, if the senior officials are going to come and defend, that might create doubts about impartiality, because it gives you a feeling that the government has already come into a particular, it has taken a particular stand, or it has come to a conclusion, and then it wants to use the particular, or the it wants to use the judicial committee to enforce that particular conclusion. This should not be so. The very purpose that you want to have a committee in place, or investigative committee in place, is because you want to know what happened. Now, if you have already arrived at a conclusion, what is the necessity for that committee? It did not, see, the court did not silence or blame officials. It just said, your action is creating doubts in the minds of the people. It's creating doubts in the minds of the victims. It's creating doubts in the minds of the alleged, the accused who've been taken to the court, and that is fair. That doubt, there is a scope for doubt, has been provided by the government and its actions. The editorial omits how SC faulted the Madras High Court. It just glosses over it. The Madras High Court single bench, aided by Justice Senthil Kumar, he took suo cognizance of, in a PIL, in a public interest litigation, on rally protocols. The public interest litigation was about rally protocols for all political parties, and perhaps even religious events. And it went on to expand it. Justice Senthil Kumar went on to expand it into a criminal probe without jurisdiction, because the jurisdiction was with the Madurai bench of the High Court. That confusion, whether the Madurai bench is entitled to hear this or the Chennai High Court is entitled to hear it, that confusion was cleared by the Supreme Court. The editorial mocks judicial supervision as excessive, but Justice Rastogi's oversight is designed for transparency. The real reason why there is a commission headed by Justice Rastogi, even though the CBI is investigating the case, is because the court feels that just if you're going to order the CBI, then people will say, no, CBI can be influenced by the government, the central government, so on and so forth. So it wants to remove that doubt. And therefore it says there will be retired Justice Rastogi who will head the commission, and there will be 2 IPS officers who will be non-natives of TN, who are not residing in TN. And they will report monthly to the court to ensure impartiality. The editorial goes on and hints petitioners were unaware of their cases. This is about 5 petitioners who are claiming to be victims, out of which 2 of them are now coming out and saying that they have nothing to do with the petitions. It was done without their knowledge. Their signatures were taken without their knowledge, so on and so forth. If that is true, the SC can take note and address it separately, which may affect the order later, because the SC itself on that day, those 2 people came on video conferencing and said that one lady, who is the wife of the petitioner, said this man who is the father, the biological father of the kid that died in that particular stampede, did not take care of the kid, was away from the family. This is a family dispute. Now, how can that be brought into this case? But still, the court was reasonable enough to listen to them. And then it said, if you are making a claim that you were not aware of having filed these petitions, but yet these were filed in your name, then there can be a separate independent probe into that. The CBI can probe it. It is not new for us that a complainant is threatened. The same Karur has an infamous minister, Sendil Balaji. The very charge against him is that he intimidated the witnesses. He intimidated the complainants, and therefore he lost his ministerial berth. And today he is continuing as an MLA who is an accused in the job racket case. So it is not new for them. But still, the Supreme Court goes about to say that it will take note of it and address it separately. And it may affect the order later, but for now, the directions stand. The directions of the interim order stand. The Hindu treats this unverified allegation because it's an unverified allegation. The court is yet to take, investigate the matter, yet to ascertain whether the claims made by these two petitioners out of those 5 that they were not aware of these petitions being filed. The court has not established it yet. So how did Hindu arrive at that conclusion? We don't know. In short, the Hindu, mistakes judicial caution for overreach. The judiciary has to be cautious. When it sees there can be reasonable place for doubt, then it has to interfere, which is exactly what the judiciary did in this particular case. Whereas the Hindu goes about, and we know who would have influenced it, in Ram, who claims that he is always accompanying the chief minister. Whether the chief minister goes for a walk or the chief minister is in his office, he even went on to claim that when the Karur incident happened and the information came in about the incident, the chief minister was sitting next to him. So he is trying to come out and cast aspersions on the interim order passed by the Supreme Court, which is agreed and accepted by everybody, almost everybody, that it is reasonable. It has taken into consideration the doubts raised by the victims. It has taken into consideration the doubts raised by the other petitioner, the TVK, that they don't want to be, judged by a media trial. And they find this disturbing that you have the officials and officials coming out making statements which they're not just statements. They almost look like the state government has concluded what has happened, and then they launch an investigation, which is a farce, which is exactly what has happened here. So the Hindu, in its editorial, has only cast aspersions on the Supreme Court and does not do justice to a neutral reporting. We've seen many instances where the Hindu has exposed itself, and this is yet again one of it. Thank you for your time in watching this video. See you again.